You see the flashing red and blue lights in your rearview mirror. Your heart pounds. You pull over, hands tied on the wheel. An officer approaches. The next words out of your mouth will determine everything. Whether this ends with a polite "have a nice day" in 5 minutes or escalates into an hour-long roadside ordeal, a vehicle search, or even an arrest. This isn't about guilt or innocence. It's about procedure and knowledge. Every single day, drivers who don't know their rights inadvertently turn simple stops into prolonged nightmares. But here's the critical fact. The vast majority of traffic stops can be concluded rapidly and safely if you understand the legal framework and use precise, strategic language. For over a decade, I've dissected traffic stop case law, analyzed hundreds of hours of body camera footage, and studied Supreme Court rulings and police training manuals. This research reveals a pattern. Officers are trained to use specific conversational tactics to extend encounters and gain consent. Conversely, I've identified 5 counter strategies, verbal tools that force the interaction back onto a narrow, legal path. These phrases require the officer to justify their actions on the record, often compelling them to end the stop if they lack proper legal grounds. This is strictly educational content. I am not your lawyer. For legal advice pertaining to your specific situation, you must consult a licensed attorney in your jurisdiction. I will now detail these 5 strategies, providing the exact phrases, the legal reasoning behind them, and real-world examples of how they change the dynamic of a traffic stop. Strategy 1. The status inquiry, defining the battlefield. The mistake most make. The officer returns your documents and asks a friendly question. "Where are you headed tonight?" Or "What's the hurry?" You answer, thinking it's polite or harmless. This is a critical error. You have just transitioned the stop from a mandatory detention for the ticket to a voluntary conversation. Every detail you offer, coming from a bar, heading to work, provides potential reasonable suspicion for further investigation. The strategic move: force a legal definition. Your first and most powerful question is calm, clear, and unequivocal. "Officer, am I free to leave?" Or, "Am I being detained?" Why this works with surgical precision. It demands clarity. It forces the officer to declare, on the record, the legal nature of the encounter. There are 3 types. Consensual, you can leave. Investigative detention requires reasonable suspicion, and arrest requires probable cause. Officers often blur these lines. It places a clock on the stop. Upon handing you a warning or ticket, the original mission of the stop is complete. Your question directly invokes the Supreme Court's ruling in Rodriguez v. United States, 2015, which states police cannot prolong a stop beyond the time needed to handle its initial purpose without independent reasonable suspicion. It creates a record. Body cameras are recording. If the officer says, "You're free to go," but then continues to ask questions, any subsequent detention is likely illegal. If he says, "You're being detained," your follow-up is, "I understand. I invoke my right to remain silent." This stops the fishing expedition cold. Scene comparison. Wrong. "Officer, where you coming from?" Driver, "A friend's barbecue." "Officer, have anything to drink?" Driver, "Just a couple." This has now become a DUI investigation. Right. "Officer, where you coming from?" Driver, "Officer, am I free to leave or am I being detained?" Officer, "I'm just asking." Driver, "I understand. Am I free to leave?" The officer must now either release you or state a lawful reason for detention. Strategy 2. The detention timer. Is this stop over? The mistake: assuming the officer can hold you as long as they wish after writing the ticket. This is false. The strategic move: invoke the time limit. Once you have your license and ticket/warning back, ask, "Officer, has the purpose of this traffic stop been completed?" If the answer is yes, your next question is, "Then am I free to leave?" The legal leverage. This question is a direct application of Rodriguez. The mission of a stop for speeding is to check license/registration and issue a citation. Once done, you must be released unless new, articulable facts have emerged, e.g., smell of alcohol, visible contraband. If the officer hesitates, your next question is crucial. For the record, what specific, articulable suspicion do you have to detain me further? Vague answers like "you seem nervous" are often insufficient in court. Strategy 3. The consent blocker, your most powerful shield. The mistake: believing you have nothing to hide and consenting to a search. This is the single greatest error you can make. Officers are trained to phrase searches as casual requests. "You don't mind if I take a quick look, do you?" Or, "If you've got nothing illegal, you're okay with me checking, right?" The non-negotiable move: a clear, unambiguous denial. You must say, "Officer, I do not consent to any searches." Say it firmly. Repeat it if asked again. Why you must never consent. The Fourth Amendment protects you from unreasonable searches. A search without probable cause is unreasonable. Your consent makes an otherwise unreasonable search perfectly legal. Once you consent, anything found, whether it's a forgotten pill bottle, a friend's pocket knife, or legal cash, can be used against you. By refusing, you force the officer to either let go, articulate probable cause, a much higher standard than reasonable suspicion, to conduct a search anyway. If they cannot, and search regardless, any evidence found may be suppressed, thrown out in court. Strategy 4. The scope challenger, questioning orders. The mistake: blindly obeying all orders without understanding their legal basis. While you must comply with lawful orders, you have the right to understand them. The strategic move: clarify and document. If ordered out of the car, Pennsylvania versus Mims allows this for officer safety. Ask before moving, "Officer, are you asking me or ordering me to step out?" If it's an order, ask, "For the record, what is the specific safety concern requiring me to exit my vehicle?" Then, as you comply, state, "I am complying under protest, and I am keeping my hands visible." The rationale: this does not mean you disobey. It means you create an audible record of the interaction. If the officer's reason is vague or pretextual, "I just want you out," and this leads to a pat-down or search, your attorney can challenge the legality of the initial order. Complying under protest preserves your rights for a later legal challenge. Strategy 5. The explicit invocation, silencing the interrogation. The mistake: simply clamming up. In the 2013 Salinas versus Texas ruling, the Supreme Court held that mere silence can be used against you as evidence of guilt unless you explicitly invoke your Fifth Amendment right. The legally binding move: invoke, then truly remain silent. The magic words are, "I invoke my right to remain silent," and "I want to speak to an attorney." Say both parts. The first stops questioning. The second triggers your Sixth Amendment right to counsel, which makes any continued interrogation a serious legal violation. The power: once invoked, officers must stop all questioning. Any further pressure or questions they ask can render subsequent evidence inadmissible. This strategy is your firewall against self-incrimination during a high-stress situation. The foundational protocol: first 30 seconds. Before any verbal strategy, your actions set the stage for safety and control. Pull over safely, turn off your engine, and turn on your interior dome light if it's dark. Place both hands clearly on the top of the steering wheel. Do not reach for anything until instructed. Only roll your window down 2 to 3 inches, just enough to pass documents and communicate. This limits plain view, claims, and unauthorized reach-ins. When retrieving your license and registration, verbally announce your actions. "My registration is in my glove compartment. I am reaching for it now." The ultimate takeaway: a traffic stop is a courtship of consent. The officer's goal is to obtain your consent to extend the stop, ask questions, and search. Your goal is to politely, firmly, and knowingly withhold that consent unless they can meet a specific legal burden. You are not being rude. You are invoking constitutional boundaries. Memorize these 4 core phrases. Practice them. They are your tools. Am I free to leave? Or am I being detained? I do not consent to any searches. I invoke my right to remain silent. I want to speak to an attorney. Knowledge dispels fear. With this knowledge, you replace anxiety with a calm, respectful assertiveness of your rights. The flashing lights become a minor inconvenience, not a portal to a legal nightmare. A final, crucial reminder. This guide provides general education on U.S. law. Laws and interpretations vary by state. This is not legal advice, nor does it create an attorney-client relationship. For guidance on your specific circumstances, please retain a qualified local attorney. Now, I want to hear from you. What is the one legal nuance or gray area about traffic stops that you find most confusing or worrisome? Have you ever used a similar strategy, and what was the outcome? Share your experiences and questions in the comments below. Let's create a constructive discussion to help everyone be more prepared.